An alternative dispute resolution means a way of settling our differences without having to go to court, and yet it's done in an organized and judicial manner. Alternative dispute resolution is the resolution of legal disputes through methods other than litigation, such as negotiation, mediation, arbitration, summary jury trials, mini trials, and neutral case evaluations, as well as private trials. Well, you're probably already thinking you said trial an awful lot, but you said it was not judicial. And it's not judicial. All of these forms of alternative dispute resolution are not offered by the court system. They are offered as private, external incentives for people to settle their disputes quickly and easily without having to go to trial. I know I mentioned conciliation when we were talking about the judicial system. Conciliation is when parties sit down together face to face and try and settle a case. That's before anybody even files anything. So let's talk about the basics of alternative dispute resolution and why should we select that particular method. Well, we should select alternative dispute resolution because we're concerned about keeping down costs. It costs a lot of money to have attorneys involved in things. It costs a lot of money to file with the court. It costs a lot of money to pay on a continuing basis all the court fees. It costs a lot of money to pay a settlement. It's just very expensive to go to court. So when we think about alternative dispute resolution, we have to realize that all of those costs are not there. It's much less expensive. Next is, how quickly do I want to resolve the dispute? Think about what we talked about when we were talking about the length of time it takes to put on a court case. When we say a quick and speedy trial, what are we actually saying? Go ahead. No longer than a year? Okay, it might not be any longer than a year. Anybody else? Quick and speedy is as quick and speedy as it can be done. Not necessarily even in a year. Some trials last 3, 4, 5 years. It just depends on how much evidence, how many witnesses, what the delays are. Can they find everybody? Is there evidence that needs to be correlated? All of that sort of thing. With alternative dispute resolution, you come in and you sit down, and sometimes you just talk face to face, and it's over in a matter of a few minutes. Maybe a couple of hours. Depends on the form that's chosen. But it's quicker than a trial. I guarantee it's quicker than a trial. And it's become very popular to have people come in and settle their disputes without going to trial because it is less expensive and quicker. Do I want to keep the dispute private? Trials are always done where? In court. And court is public. Very public. Have you ever been part of a high school class or a college class that was taking a course where they took you downtown to a courtroom and let you sit in on a trial? That's about as public as it gets. When you have people just coming in you don't know and they sit in the back of the room. It's public, it's transparent, it's supposed to be. Do we always want to put what your grandmother used to call airing our dirty laundry on in public? No. Not always. Sometimes we don't want people to know what we've been involved in. probably a pretty good idea not to sometimes. So if we want to keep it private, we want it to be resolved quickly, and we want it to be resolved inexpensively, maybe alternative dispute resolution is the way to go. Do I want to protect the relationship between the disputing parties? What if we have a contract? What if the contract is between an actor and a studio for the amount of money to be made on a film? And that actor doesn't want to have not just a bad reputation, but doesn't want to make the film production company mad at him, or his fellow actors mad at him, or anything like that. He wants everything to be kept real comfortable. Well, we might want to do this alternative dispute resolution, because when we do that, we're protecting the relationship between the disputing parties, especially if we can keep it private. So if the actor and the studio go into a room with their representatives and they hammer out an agreement, nobody else has to know about it, and it doesn't disrupt what's happening between themselves and the production company. Yes?
Don't people like do this before divorces, or like?
Do people do alternative dispute resolution before divorces? Yes. They have what there is called a settlement agreement. And the settlement agreement is actually a contract between the two spouses, which is an alternative dispute resolution type of agreement in which they've split up the property.
What is that called?
It's called a settlement, a divorce settlement, or a property settlement. It can have a lot of different names, but it's important for them to have that when they go in before the judge, because they can say that's just one thing we agree on. But what have you heard about some of those agreements from divorces?
They don't get like a resolution.
They get real messy, don't they? People get angry at each other. They try and hammer out the agreement, and it doesn't work. That's when they have to go before the judge. It's still an arbitration or a conciliation. We'll call it more of a conciliation, and I'm going to go through each one of those, the types, in a minute or two. Yeah.
So is it like, so what if you have like a kid?
Like have a child.
Yeah, like if you have two, that's like one goes the other? Or like,
No. No. When they're working on creating the settlement agreement that is going to govern the rights of the parties in the divorce, children are a special part of that agreement. First, they have to decide, are they going to have custody for the mother, custody for the father, or joint custody? Now, they can work on any of those. Then they have to work on visitation rights. They have to work on education and support and all of that. That can become very contentious. It's very lucky to have two parties and two attorneys that will sit down and work out an agreement smoothly in a divorce. The children, however, also have a say. And there's two ways this can be done. First of all, if the children are young enough, where the court does not feel that the safeguards that are in place to work on the agreement are sufficient, the child will be appointed what we call a guardian ad litem. A guardian ad litem is essentially an attorney who works just for the children. The only interest that has is in the well-being and the provision for the children's needs. And when the agreement that the parents work out is brought together in court, the guardian ad litem then gets up and testifies as to what the children need and what his opinion is of, is it going to be covered correctly?
As far as like financial wise.
Financial wise, education wise, health, support, all that sort of thing, living conditions. But the children, if they're above the age of 12, sometimes in some states have very special privileges. The judge calls them into no, you don't bring the laugh track on yet. Asks them to come back into chambers with the attorneys for both of those parties. They're trying to make the agreement. And that judge says, who would you rather live with? And the child is allowed to give their opinion. I would rather live with my dad. I would rather live with my mom. I can live with either one of them. It just works out that the child has the opportunity. Then the judge takes the best interest of the child under consideration and makes the decision as to who is going to have custody. You had another question. Did I answer it?
Well, I think I was going to ask, what if the child does say, it doesn't matter?
It doesn't matter. Then the judge, taking all of the things into consideration that he's seen so far in the courtroom, everything that's in the settlement agreement, everything that's in the custodial agreement, looks at all of that and says, I believe it is in the best interest of the child to be in the custody of their mother. Well, then that becomes that. Or he says, I then agree that both parents may have joint custody. Any additional arrangements thereafter that they want to change have to come back in before the court.
Isn't that messy though, to have a kid choose?
It can be extremely messy, it can be very contentious, and it can be very hurtful to the spouses and to the children. Yeah, very much so. So what the judge is trying to do is to protect the relationship between all the disputing parties. Then, am I concerned about vindication? Does that court tell me that I'm right or not? That's what I want. I want a court to tell me I'm right. Well, if I go to alternative dispute resolution and just try and work it out, is that agreement going to say, oh, I'm right? Well, maybe it isn't, because alternative dispute resolution is meant to make things equal and fair to each party. No matter how many parties there are. There could be 6 parties in a conciliation or mediation or an arbitration. So we just have to make sure it's fair and workable for all the parties. So if they're concerned about being vindicated and having somebody say, you're right and you're wrong, maybe alternative dispute resolution is not the right place for this particular case. Yeah.
Now, when people go to, you know how some people go on that show, Maury?
Yeah.
So people go on that show to figure out whatever they're trying to figure out, and they still gotta go to court.
Oh yeah, that's a TV show.
But that's so fake.
That's fake.
I'm trying to figure out why they do that thing.
Why people getting it? Why people run
That's how it really
I thought it was okay.
It's theater. No matter whether it's fake or it's not, all of those shows are theater. And they're like actors on a stage portraying some special incident that occurred. Yeah. Okay? So, do I want to set a precedent with the resolution of my disputes so that somebody else is going to be able to do the same thing? Remember the knight and the turnip cart? He wanted to set a precedent with Farmer Brown in order that others would know what they had to do to follow that particular bit of law. If they want to set a precedent and get it set so that other people will have the same advantages as they had in court, maybe alternative dispute resolution is not the place for them, because alternative dispute resolution never sets anything out in writing that would apply to anyone else. just the parties that are involved. There are three primary forms of alternative dispute resolution. The first one is called negotiation. This is when the parties sit down face to face, just the two of them. Just Miles and Khalid. And they sit down and they're going to work out their disagreements face to face and come to an agreement. That's the easiest, the simplest, and the least expensive way of doing it. Nobody ever finds out about it because they're in a room by themselves, sitting across from each other saying, hey, look, this happened, this is what I saw. The other says, this happened, this is what I saw. I don't like what happened here. The other says, I don't like what happened here. How can we fix this? That is conciliation, which is also called negotiation. Conciliation means to make it right in a gentle fashion. Okay? That's conciliation. That's the easiest, the simplest, and the quickest way to resolve a dispute between two parties. Mediation is the next step. Mediation says we're going to have the parties, one on one side of a table and the other on the other side of the table. And in the middle, there's a guy or a gal that we call a mediator. The mediator listens to the first set of difficulties with whatever the situation was. The technique the mediator uses is one of repetition and request for additional information. So I'm going to be the mediator. The people on this side of the table are going to tell me what happened. I internalize and think about that for a minute. I turn to the other party on the other end of the table who have not said anything yet, and I say, party number one says that this happened, and I restate everything. And I turn back to the party that just told me that, and I say, is that correct? If they say yes, then I turn back to the party and say, they agree that what I told you was correct. Please think about this for a moment. If they say no, then I have to restate it for these folks again until they do understand what they said. And frankly, that I understood what they said, so that I can get everything right going back and forth. Then this party tells me what they think about what I just said and give me their version, and adding detail, I internalize that and think about it, and I say to them, this is what I just heard you say. They tell me, yes, you're right, or no, you're wrong, and if I'm wrong, that they restate it so that I have a good understanding of it. I then turn back to the other side of the room and I say, this is what these people we'll call B said about that, and what they told me and corrected me in saying, so this is what they say. And we keep going back and forth like that in mediation until everybody agrees on what actually happened and what needs to be done. Once everybody knows what needs to be done, then we come up with a solution the same way. Okay, so what is your solution? A will tell me what their solution is. I repeat that solution back to A. They say, yes, that's our solution. I turn to B, repeat the solution to B, and they tell me that's a terrible solution and give me theirs. Okay? And it keeps going back and forth like that until we finally have the whole thing worked out. That is mediation. See, it's more complicated than conciliation, isn't it? Because I could put Miles and Callie in that room, and if they don't agree, they tell each other they don't agree. And they work out what their disagreement on the disagreement is all by themselves. But it's quicker, because they don't have to go through somebody else. Mediation has to go through the guy in the middle. The guy in the middle is sometimes stressed after this is done. But it gets worked out. Arbitration is much closer to a trial. Arbitration has someone who is appointed by the both parties. They agree on who the arbitrator should be. He is an individual who sits at a separate table. The parties thinking A are on one side, and the parties thinking B are on the other side. They can be represented by attorneys. They bring in witnesses. They examine the witnesses, whether they're individual witnesses or expert witnesses, if it's that technical. And then the arbitrator takes what both parties have said and all of the evidence that's been accumulated. He takes that somewhere else, may take several days, and comes up with a decision. The arbitrator comes back and says, I heard what both of you said. I've internalized this all. I've thought about it. Here's my decision. And he makes the decision, or she makes the decision. The parties don't have to agree. The arbitrator is making the decision and comes up with the resolution of the problem. Kind of like a judge. So that's more like a trial than mediation was, because the parties still have the ability to hammer out their own resolution and what they're going to do about it. Arbitrators, once the arbitrator makes the decision, that can be it. It's called binding arbitration. Now, is all arbitration binding? No. It has to say in the initial agreement that brings the parties together that the arbitrator and their decision, once made, is binding on both parties. Otherwise, it's not. So what if the arbitrator makes a decision that nobody likes? What do you think we can do about that? You can take it to court. Yes, you can. You can file a lawsuit, just like probably one of the parties wanted to do in the first place. No, this is a brand new issue. It's a brand new issue. But here's the fun thing about doing an arbitration and then taking it to court. Everything that was said in the arbitration, if it was taken down by a court reporter and it was done under oath, can be used as evidence in the trial. So it's kind of like an appeal, isn't it? Only the judge is going to make the decision in that appeal based on what the arbitrator said. A lot of times, your choices are limited. Limited by what happens in front of the arbitrator, limited in front of what happens with the judge. But you can bring in all those witnesses in court on the appeal, and in fact, you can bring in more witnesses. If the first set didn't work out, you bring in new ones. Okay? So, the arbitration is much like a trial. The second one that goes to court, it is a trial. All right? Another thing about the arbitrator is, let's say that you have a very technical issue that involves chemistry. How many chemistry people do we have in here? Any chemistry majors? Probably not? Okay. Do we have anyone in here that's interested in restaurant management? You're my arbitrator. Guess what? When the parties apply for an arbitrator, they don't get a say in who the arbitration association sends down to them. You'll be trained in how to be a good arbitrator. You will have taken all the courses. You will have that on your resume. But you could be a restaurant manager that's sent in to arbitrate maybe a medical procedures arbitration. doesn't seem to fit. Or maybe somebody who has a building that has problems in construction has all of these engineers come in and they're testifying about engineering, and their arbitrator is a dentist. It can happen, because when you apply for an arbitrator to the American Arbitration Association, you don't know who you're going to get. Unless the parties in advance have agreed. See, there's always an unless or a but. Unless the two parties have agreed that the individual has to be specially qualified, like he has to be an engineer, or he has to be some sort of a physics professional, somebody like that, so that they get the engineering, they understand the concepts, they know what stresses are, they know what building materials will do under certain conditions. They just understand it, they get it. You always hope you can get an arbitrator that just gets it, okay?
Why do you have both parties so they agree on the arbitration?
Pardon me?
Doesn't both parties have to agree on who it is then?
Yes.
So there's a randomly both say something?
What they do is they say, we'll agree to pick an arbitrator from the American Arbitration Association. When they do that, or another association of arbitrators, when they do that, that association tries to pick someone who is as close in occupation and understanding as they can. So if a dentist is the closest person they have to understand the scientific principles, it goes into the stresses of building materials, because they work with gold and silver and other ceramic materials and know their properties. Maybe that's the closest they can do. Okay? There's some other ones. We mentioned conciliation, mediation, and mediation arbitration. And mediation arbitration is kind of a halfway point between the basic mediation and the basic arbitration. It's kind of halfway. In a mediation arbitration, the arbitrator is a mediator because they don't render a decision. The decision is up to the two parties, and it's more like a conciliation, but they're arguing two sides, and the arbitrator, or the guy in the middle, is just there to keep order. Okay? Did that confuse anybody in the difference between mediation, conciliation, and arbitration? This is kind of a half and half thing between a mediation and an arbitration. Are you okay with mediation and arbitration and how they kind of look like? You hear a lot of times, anybody here union? I used to be union. I was a state worker at one time that was part of a labor union. Well, labor unions use binding arbitration a lot. And there are other employment scenarios where an individual's employment will say, we have to take this to arbitration. You cannot sue once you sign the contract. And if it goes to arbitration, then essentially what we have is almost a trial-like situation where witnesses from either side come on, and the arbitrator is actually appointed by the National Arbitration Association, and they're a specialist in employment law and employment arbitration. A summary jury trial. A summary jury trial is a kind of a little mini trial where everybody puts on their witnesses, then the guy who would be the arbitrator issues a decision. It's non-binding. It's non-binding. It's very much like a trial. The mini trial, a mini trial is exactly like a trial in state court, except that there is no public viewing of it. It is not held under state law. It has no force of state law. It doesn't use a judge that is currently sitting, but everything else is the same. So they have witnesses, they have a recorder, they have a trial judge who is probably retired and hears these private trials, and they have a jury. They actually can have a jury. But the juries are not empaneled and sworn the way a jury in the court trial, which is held by the state, would be empaneled. They are simply brought in, they are paid to be there, they are paid for their verdict, they deliberate, and they may have special skills, unlike trials that we go into where you get a jury of your peers. The term peers is defined differently. The term peers in a mini trial means if this is about an engineering problem, those jurors might all be engineers, and they're paying them to be there as engineers to hear this mini trial. So, the verdict comes out just exactly the same way it does in a court trial, from the jury after deliberation and consideration of all of the witnesses and all of the testimony. Problem is, that's all the farther it can go. If they don't like the way it came out, one of the parties can file a lawsuit, start all over again. Only this time, they have to take their chances with a jury of their peers, which would be someone selected from a pool of jurors in the general public. Okay? Early neutral case evaluation. This is not a trial, an arbitration, or a mediation at all. This is where all the facts, all the statements, all the evidence are submitted to an attorney who has a specialty in whatever area this is. And that attorney sits down, reads all of that material, researches all that material, and comes up with a decision and a recommendation. He says, I recommend that this not go to trial, that you just go ahead and settle this. Because if it does go to trial, here's what I believe the result is going to be. And these people usually have so much experience that that's usually what's going to happen. So they let the individuals know what it is and say you can either take this and go to court or you can settle it. This is less expensive than a mini trial, less expensive than a summary jury trial, and less expensive than an arbitration. And then we have a private trial. Private trials are trials. They have peer juries, individuals who are selected who would be just like the individuals that you would face in a state court. They have a real judge who comes in and sits on that. He is not sitting as a state judge, however. He is sitting as a judge in the mini trial. You have attorneys, you have a court reporter. It's like a real fancy deposition where everybody gets to be examined, cross-examined, and the jury gets the case, makes a decision, gives it to the judge. The judge then reads it in court, and that new decision is what's either accepted or rejected by the parties involved. What are the advantages of arbitration? Well, they're more efficient. They get things out of the way. Any of the trials, mini trials, arbitrations, mediation, conciliation might only take a few days. If they went to trial, if they were in the state system, it might take weeks. Less expensive than litigation. We've talked about that right at the beginning. It is very much less expensive. Many times the only expense that you have are the attorneys who work on the case and the arbitrator using an arbitration. Or if you're using a mediation, it's the mediator and his travel expenses, or her travel expenses. Parties have more control over the process because they can choose the arbitrator and they determine how much formality or how little formality they want. Do they want attorneys, or do they just want to represent themselves? If someone wants to just represent themselves, then the other party will represent themselves. They'll agree that nobody will have attorneys. Well, the cost down. The disadvantages, well, there are often scheduling difficulties with arbitration panels because sometimes you have to have it in one place, and then in order to keep things fair, you have to take it to the other place. It's like having the 7 games of the World Series, you know? You have to alternate the venue in order to keep it fair so that somebody doesn't feel like they're under too much pressure at any particular time or on an ongoing basis. The difficulty of appealing an arbitration award. It's very hard once the arbitrator makes the award or makes the decision to appeal it, because the only route of appeal may be to go to court. And then that becomes expensive. So you have the expenses of the court and the trial, plus the expenses of the arbitration. The trend toward arbitration may reduce its efficiency. Our court system has a lot of cases in it. And more cases are in the court system the longer the trials take, because judges have to hear trials in the middle of other trials. Arbitrations, because they've become so popular as a manner of dispute resolution, often have the same thing happening, where there are not enough arbitrators going around, so they have to hold arbitrations in addition to other arbitrations. So they're working several at one time, and it becomes almost a system that is subject to be clogged, just like our court system sometimes seems to be clogged. Companies and employers may effectively hide their disputes through arbitration. If the city of Flint, Michigan had decided to go to arbitration over the lead pipes and the lead in their water, rather than allow people to know about it and go to court, then Flint could have hid, or we call it cover up, and kept private, non-transparent, anything they were going to do about the problem. Well, they still haven't solved the problem, but at least they're working on it and we know about it, and so the pressure is still on in Flint, okay? Sometimes companies can hide their disputes and hide the outcomes and the evidence because it's not public, okay? It's not public. Whereas if they were at trial, it would be very public. And you would have vans from all the news networks sitting outside with reporters inside in the public gallery, listening and taking notes and then coming out and reporting right away to their news networks. In fact, if you remember the Paul Manafort trial, where he was on trial just a few weeks ago, one of the classic pictures is one of the interns from CNN running in her dress and no shoes, just running flat out to get her information out on the decision of the jury before anybody else did, so CNN could get it on the air first. And that it's you look that picture up, you can find it. It's all over the internet. She's just flying out of there. But it's public. That decision was public, and she got it out there. So when we create binding arbitration clauses, what kinds of things are we looking for? First, we look to be clear and unmistakable. We have to say what we mean and mean what we say. We have to ensure that the arbitration clause is bilateral, so that both parties know about it, both parties are informed, and both parties will abide by it. We have to state explicitly which party will pay the arbitrator's fees and make sure that it will not cost the employee more to arbitrate than it would cost to litigate. So we want to keep the cost low. want to specify how the arbitrator will be selected. This needs to be in the contract. And we want to specify the costs associated with the arbitration. So you can pay for this, you can't pay for that. We want to avoid limitations on the remedies available to the parties and consider other potential parties when determining where to hold the arbitration. If we're going to hold one, maybe in Knoxville and maybe in Memphis, a better location for both might be here in Nashville, which is halfway in between, which is easier for both parties to get to. Then we talk about court-annexed alternative dispute resolution. What do I mean by court-annexed? What I mean is the court can order. The court can actually order alternative dispute resolution in any one of those forms. Courts like alternative dispute resolution because it's out of the court's jurisdiction thereafter, but will accept its decision. So all they have to do is review what occurred in the various form that has been selected. And then in international disputes, alternative dispute resolution is the preferred form. They do not like to go to trial. They perform in the law of the country that's stated in the international contract. So if I'm doing a sales and shipping contract between the United States and France, I can choose any law of any country that I want in that contract to govern that particular transaction. So I can, even though it's between the United States and France, I could pick German law. And it would be arbitrated, or any dispute would be settled under German law. Okay? We'll talk more about that when we deal with international law. That's the end of today. Please, on Thursday, go to the session over in the Appleton room, dealing with finance. And we will not have class so that you can do that. Get your exams in by midnight on Friday. To my email.
Don't we have a paper?
That's it. Oh, okay.
So it's within our rental.
It's in the files section in Canvas. Make sure you get a look at that. It's the same thing. Yes. Yes. It's all one and the same. Did everybody get to sign the roll? Where did the roll get to? Okay. Class sitting. I thought we agreed on Thursday.
Now, how do I register for the class? Like, it's not on my.
You are already registered, Miles.
Oh, you handled it?
I